Good afternoon from India, but good morning to all of you. In today's presentation, Sharmisha and I would be basically walking you through or like trying to make a case for whether or not we should have an international environmental law court. Unfortunately, Kanika was not able to join us because she's in the middle of a hearing. So if we are lucky, she'll join us, but otherwise it's just going to be the two of us. So in today's presentation, we'll start off by talking a little about what are the different arguments that are already in place to have an international environmental law courts, because of course this topic is not new. It has been spoken about a lot, but at the same time, there's always scope for some of the other more innovation, creativity involved to back the case for having an environmental law court, and that's what we're trying to put forth. So first we'll start off by giving you a general introduction about IELC, International Environmental Law Court. Then we'll talk about some of the international forums and regional forums already in place, wherein which environmental disputes have been brought forth, or any of the other mechanisms that are in place wherein which enforcement is ensured, or at least the endeavor is to ensure enforcement. Then we'll be looking at some of the national jurisdictions. So since we have paucity of time, we'll be concentrating primarily upon India, but wherever we feel that there's a need to address or make mention of any other jurisdiction, we'll surely be doing that. But in general, we'll primarily be concentrating about India itself. The reason why we are trying to look at a particular jurisdiction is basically to draw inspiration from it in terms of how in India you already have a specialized court. And of course, there has been a lot many writings on this front as well. When you talk about India, the specialized courts have been very successful. And of course, my colleague, my friend Sharmishtha will be delving a lot more into that aspect of it, of how the Indian courts have been very successful. After that, we'll be delving into less of a monologue on each of our ends, and we'll be engaging in a dialogue. By that, I mean, since we'll be talking about the pros and cons of having such courts, and we'll be talking about what the composition of such courts are in general, we'll basically be sharing a dialogue amongst us. And if at any point anyone from the audience also feels that they would want to engage in that dialogue, please feel free to do that. But we thought we'll make the most of the fact that since we're two people, it made more sense for us also to have a conversation. And that's how we'll basically make our case, and also make a case of what kind of a composition are we looking forward to when we talk about an international environmental law court. Of course, there'll be certain caveats, like one major caveat that we will be delving into is the North-South divide. But again, you have to wait for the end of the conversation for that. So my name is Aakriti. I am an assistant professor at Jindal Global Law School. Kanika, who is not here at this point, is a research associate with the Competition Commission of India. And Sharmisha, you can please introduce yourself, and then Sharmisha will take you through the introduction for today's presentation. Thank you, Sharmisha. Please.
Thank you. Thank you so much, Aakriti, for gracing this audience and apprising them as to what our case is. And on behalf of Kanika, let's still apologize. She's in the middle of a very important hearing. That's why she couldn't join us, and she's highly apologetic, and she wants you guys to excuse her. My name is Sharmisha Shukla. I am an environmental lawyer, and I take up cases for the Union of India at the Supreme Court of India. That's the highest level of jurisdiction and highest court in India. And there's a specialized body called the National Green Tribunal. That's a specialized environmental court which is running in India. So I take up cases and obviously pro-environment cases at the national level, as well as the region, as well as the district level, which is there. So yeah, as Aakriti is appropriately and aptly introduced, the main case that we are putting forward today is whether it is the right time to have an international law court, an international environmental law court. And so we'll just guide you through it. Okay. So as many of you would have read our abstract, so what we are trying to establish and put forward in our case is that, as since time immemorial, if we go into the back to 1972, the United Nations Environment and Development Conferences, the Conference on the Human Development in Stockholm in June 1972, and the areas and the years before that, everybody has talked about how environment is a very big issue, and talked about participation also. This topic is not new, but over recently, this topic of international environmental law court has come up. in the last 2 decades or so as a concept has come up. And that is what we're trying. However, there's hue and cry about it at all the conferences, whether it's the Paris conference or the COP26, when we talk about the need and the importance and relevance of establishing a court at the international level. However, everything just goes on the list of priorities. There's just, comes to the bottom of the priority list is what I can understand. So we are trying to put forward the case of putting up with an IELC and put it on top priority. And why is it of utmost importance to take care of environment in the context of, and talk about environmental jurisprudence and establishing environmental jurisprudence at the global level, and having a body which is having a standard compliances based in procedures which can be taken over by the rest of the countries all over the world and take benefit from that. So yeah, so as far as the introduction goes, we talk about the emerging trend around the world demands environmental justice and creation of a separate and distinct international body. However, as we can see, policymakers both, like we'll be talking later on about the North and South divide, which is presently going on and continues to go on time immemorial, obviously breaks away from the traditional judicial boundaries. The need of the hour as such is that during such dynamic changes, with the pandemic coming in and a lot of environmental changes happening, apart from obviously the losses that we've faced, both economically as well as loss of lives, human lives, which has come in. The issue of environment becomes all the more important. The need of establishment of an IALC becomes more relevant here. Next slide, please, Aakriti. Aakriti.
Thank you. Thank you so much, Sharmishtha, for the introduction. Yeah. So before we delve into the whole conversation of the international organization, courts and tribunals already in place who are addressing these issues, let's start with something very basic. Because whenever we talk about environment, and this is something that Sharmisha will be delving into in a lot more detail, especially in context of India, it's usually argued that national forums are a lot better placed when it comes to implementation of environmental obligation, or bringing forth a case for environmental obligation for that matter. And we're not saying that they're not. And during the course of the presentation, you'll also come to know why we would always also try to make for a case for national jurisdiction to have a very huge role to play. And that's also true, not only like we can draw, if you were to draw inspiration for, say, from international criminal courts and criminal jurisdiction, and you have the ICC, which would only look at grievous crimes, and then you have national jurisdictions wherein which the other crimes would also be dealt with. So if you were to draw inspiration from there too, of course, we would want to support having a national jurisdiction very much in place, dealing with issues pertaining to environment. But there's one catch in this, and that catch is, first and foremost, when you look at national jurisdictions, it's very important for them to be signatory or would have ratified or acceded to an international convention. So that is the first catch. And for instance, if they do accede to it, they have ratified it. The second one is whether it's a monist or a dualist country. So if it's a monist, our problem is solved directly. The international obligation will be directly applicable. But if it's a dualist country, then of course you would want to transpose the laws from an international agreement into your national legislation itself. And chances are that at times such an obligation or commitments can also be watered down. So in that way, at times national jurisdiction can also lack, because it might not always be able to address all the obligations or duties or concerns that they've signed up for under an international convention. But again, as you'll see as the presentation progresses, they do play a major role. But that is one of the reasons why we're also looking towards an international forum wherein which such issues can be dealt with. Now, when you talk about international forums, you look at what kind of parties are involved. Like for instance, international organization, non-state actors, states for that matter. Now, if we go by a step-by-step procedure, we look at the forums wherein which international organizations would also have a say, or non-state actors would also have a say. So if we look at international organizations, the kind of conventions that allow them a voice or allow them to bring forth proceedings would be something like OSPAR Convention, UNCLOS, EU Commission, the European Court of Justice for that matter, are all forums wherein they can still be given a voice. International organizations can be given a voice. But again, apart from UNCLOS and the EU Commission, when you look at the OSPAR Convention, it does not result in a dispute in case the particular state concerned is not living up to its obligations. So there are, of course, certain loopholes even when you look at some conventions. As far as non-state actors are concerned, of course, they are provided with the opportunity to give a report to when a case is ongoing for that matter. And even at a very domestic level, they are the backrunners. They are the ones who actually compel the states at times to fulfill their obligations and their duties. And of course, in certain human rights mechanisms also, there are certain mechanisms very much in place providing for a forum for such reports to be presented. But the third aspect is pertaining to states. Now, of course, states have been time and again the main subject of international law. How much ever we'd want to introduce new actors, they do still play a very primary role. Now, as far as states are concerned, disputes pertaining to states or international obligations pertaining to states can be threefold. One is intrastate itself, meaning there are environmental obligations that are not being fulfilled at a domestic level and other states are not being affected by. The other one is interstate. By interstate means probably 2 or 3 countries are only involved and they are being impacted. So for instance, there is a transboundary pollution from India to China, which is why China is also getting affected. So that is a dispute between those 2 parties. And the third one is an erga omnes obligation. Of course, erga omnes is an obligation that was developed in Barcelona Traction for that matter, or Southwestern African cases. But erga omnes obligation would be that even if a state is not affected by a particular infringement, they can still bring forth a case. It's like it's usually found in human rights obligations also, like Gambia could bring a case against Myanmar for the Genocide Convention obligation not being fulfilled. So similarly, even in case of environmental law, it's not recognized in all the conventions, but some of the conventions might have come to recognize such a way of enforcing rights as well, thereby which states who are not even affected per se by a particular infringement can still bring forth the case against such a state concern. Now, this brings us to the next aspect. What kind of forums are in place in case there is a dispute between the states? I mean, I did tell you a little about international organizations. I did try to tell you how, when it comes to non-state actors, it's relatively lacking. But of course, there are certain human rights courts wherein they still get a say, like ECHR or the Human Rights Committee for that matter, or even ACPHR. They allow for non-state actors to also have a voice. But what other forums are there? Now, of course, there are 2 ways of going about it. One is that you have diplomatic means, one is you have legal means. As far as diplomatic means are concerned, you can resort to procedures like negotiation, conciliation, good offices. And at times, the conventions are actually encouraging for states to resolve issues on such forums because no third-party element is involved. The states basically try to come to an amicable solution amongst each other. And this is something that we've seen, for instance, in the Permanent Court of Arbitration. It's something that we've also seen in UNCLOS for that matter, Basel Convention, sorry, not an UNCLOS, Montreal Protocol, Basel Convention, Chemical Convention, that they encourage such non-compliance mechanisms. But on the flip side, if we look at legal measures that are in place, first and foremost, we can look at arbitration. Now, again, even in a domestic context, even in an international context, many issues are being taken to arbitral tribunals or forums for that matter, because they provide you with quicker solutions. And especially when it comes to environmental law, trying to find a quicker solution can also make sense to a certain extent because there's damage that's being done right now and you'd want to take care of it. And sometimes courtroom decisions can take a longer time and that can in itself be counterproductive. So you have arbitration, which is central when it comes to means, and you have forums like UNCLOS or PCA, which encourage arbitration also. But on the other end, we also have international courts and tribunals or regional courts and tribunals. Again, we don't have an international court or a regional court which is specifically dedicated for environmental law itself. So when we talk about international courts and tribunals, whether it's the European Court of Justice, or the ECHR, the ACHR, the ACPHR, or you talk about the ICJ, you talk about the ICC, or you talk about WTO, all of these forums are now finally, they are taking up cases which are pertaining to environment, but when they take up these cases, they're usually related to something within their jurisdiction. For instance, if there is a human rights obligation that also flows from the environmental concern itself, then yes, I have a standing because human rights is something that I can bring forth in front of the ECHR. Similarly, if there's a concern pertaining to endangered turtles who are also getting impacted because of some trade policy that another country has in place, you have the WTO in place. So you can say it's always in connection to another concern, thereby which you can actually bring such a case. And of course, the ICJ at one point did try to develop a forum of the environmental chambers, but it didn't see the light of the day because it is hardly used. At one point, they had to close down such a chamber. But that didn't stop the ICJ to take up disputes pertaining to it, like fisheries jurisdiction, I'm sorry, I'm very bad at the pronunciation of it. There's a Hungary case also versus Slovakia, which is a landmark decision. There's also, of course, nuclear weapons. There are different cases that have been brought forth and are landmark decisions. But again, when you talk about the ICJ, its jurisdiction is very restricted because it depends on the parties who are party to the ICJ or bring forth their cases to the ICJ. Secondly, for the decision to be binding amongst the parties, it has to be a contentious case. Otherwise, of course, you have the advisory opinions also in place. But again, when you talk about the ICJ, the jurisdiction will be very much limited. It is primarily concerned with interstate disputes. And as we've already spoken about, as we've been talking about even in context of erga omnes obligations, not all disputes pertaining to environment would be interstate. Sometimes it need not necessarily be a dispute also. It can simply be an infringement of an international obligation or an international duty that they had to the world at large. I mean, it's similar to how Yuval Noah in his book in 21st century is talking about how there are these new concerns that are coming up in international domain, like climate change, artificial intelligence, and nuclear weapons, wherein which if a state of its own accord is working on a particular thing to control it, that in itself cannot be sufficient. You want the whole world community to work together to address that particular concern. So that is one of the primary reasons why we would want to also look at an international court, because if you look at all of these courts, whether you look at WTO, you look at ECHR, you look at the Human Rights Committee for that matter, these are all courts who are very much equipped. There is no hierarchy. That is also a concern. Each and every one of those courts can come up with their own interpretation pertaining to the International Environment Convention. But there is no hierarchy, and they have their primary jurisdiction over subjects which are not solely pertaining to environment. And that's why we're trying to make a case for having an international environmental law court whose primary concern is the environment. So more on the pros and cons, more on trying to delve into this issue. So now I'd like to hand over the space to my friend Sharmishtha, and she'll walk you through on how it is very important to look at specialized courts and what kind of success specialized courts can also have. So Sharmishtha, please go ahead.
Okay, thank you, Aakriti. So taking on further, what I want to make you guys understand and what I want to make you guys very much aware of, the reason of setting up IELC is because there are two major things which we have to take into consideration. One is the legislation, the global legislation, as well as the regional and the local laws which will be functioning. That has to be taken care of. And obviously the case laws, as Aakriti my friend has actually mentioned about the various national cases international cases which have been taken up by the ICJ, the various environmental issues. But what we tend to forget is that, there's a major issue, the major problem with setting up of the ILC, which will be there. That is the issue versus economic development versus the environmental protection. And apart from that, the most important point will be the developed versus developing country debate, which has gone on forever. So what we have to understand is that as far as if you look at the domestic laws and the domestic jurisdictions, the case laws there has proliferated pertaining to the environment. There are numerous case laws, the jurisprudence has developed, but obviously, let's take up the case of India for that. We are a massive country with a population, which was obviously the second largest population in the world, and despite of all of that restrictions and regulations which are present, we are still working with a functional and very efficacious National Green Tribunal in taking care of the environment. So that is in itself a very stronger point which we want to put forward. If a country like India can work with successfully model a National Green Tribunal, model an environmental court, then some similar things can be working to ILC. What we need to take care, however, the most important point that has to be taken care of, that international law as in itself is a soft law. So that becomes a major limitation in terms of the liability. So the major important thing that we need to take care of is to develop principles of liability for transboundary harm, which has to be taken care of. So let's take the case of India and Indian subcontinent, which is a merger of around 7 countries in the subcontinent. So and all of you a little bit, you must be aware of the Indus Water Treaty, which was going on. So the river is flowing from India and goes maybe 1/4 of the river and its tributaries are running in India, and the rest of the country flows into Pakistan. So there's a treaty which is there and which has been there since 1960, despite whatever relations we have with Pakistan or whatever. However, the environmental aspect of it that has been taken care of, and India's water treaty is one of the most successful treaties as far as the developed nations and the South Asian country and their geography is concerned. The major case that we're putting forward is that obviously the major national jurisdiction which we talk about, the most successful and the oldest of all, is the Land and Environment Court of New South Wales, Australia, which works on two major important bases to talk about. They develop and evolve their jurisdictions and whatever ambit they have, and continuously being a dynamic body, they increase. Being a dynamic body, they keep on collaborating with their case laws. The second is the Vermont environmental law, again with the US, which is again one successful model which has been taken care. However, today we'll be more delving into deep into the success model of the National Green Tribunal and the statistics pertaining to that, and the major case laws that have been taken care of. So let me just go through with some of the most famous cases or the landmark cases of the National Green Tribunal which has been there. But before going into that, I would just like to apprise you of some of the important judgments which have been passed by the Supreme Court of India in pursuance with the observations made into NGT. Before going into that, I would also try to tell you a little bit of the how the whole system works in here in India. So the National Green Tribunal has 4 benches. So the country, being a huge, massive country in itself, works under 4 different zones. So that is the North Zone, East Zone, Central Zone, West Zone. These zones have been divided based on the climatic impact and the, let's say, because India is primarily a agrarian economy, so being on the soil type, the problem. So we have, and the industries are also segregated. So let's say the western part of India consists of a lot of black soil, which is very fertile. And so there's a lot of agriculture which is happening. So more the industries which are more agrarian related industries will be set up there. So the regional bench within the national bench of the NGT, so the regional bench primarily has been established in the western zone with the headquarters there, and they primarily take up the agrarian cases and the industrial cases which are there. However, all these cases, and so in the Indian judicial system, we have around 29 states within the country, and each state has its own high court where the local laws are applicable. So what has happened with India, what India has done as in the primer itself under the Constitution of India, right to healthy environment is a fundamental right which has been given to us as per Article 21, and wherein we say the National Green Tribunal is in act to provide for the establishment of an effective and effective and expeditious disposal of cases relating to environmental protection and conservation of forests and other natural resources, including enforcement of any legal right relating to environment, and giving relief and compensation for the damages to person and property and matters connected therewith, incidental thereto. So anybody who's agreed, again, so there's an appellate body as well. Anybody who's agreed by the order of the NGT and they think that order is not there, so there's an appellate body which is in the form of Supreme Court of India, wherein you can go if proper relief is not. The major point to note here is that there is, under the various sections in the NGT Act, there are specific provisions for compensation relating to substantial damages which have been conducted on behalf of individuals or industries, which has to be submitted to the respective pollution control boards, the state or the party aggrieved, which is there. Going further, let's talk about some of the landmark cases. Coming back to that, like recently, what has happened is a lot of because India is more on the developing phase, so a lot of vehicles which are running, they don't run on gas, they run on diesel. Diesel, as a matter of fact, creates a lot of pollution and creating a lot of impact on the air pollution, which is happening in and around the major cities, which has happened. So, in the matter of, there's a matter called as Vardhaman Kaushik versus Union of India, wherein the NGT gave a landmark judgment wherein they banned the diesel vehicles. So the licenses which are given to all the diesel vehicles which are operating in the country is not more than 10 years. Earlier it was for 25 years, but now it has just been limited to 10 years. So all those vehicles will be banned for operating on the roads, and that has significantly reduced the amount of air pollution which is happening, especially in the cities. Another major landmark case which has been there, that India is a country, India is a very diverse country, and there are a lot of festivals which happen, and river is considered close to our mother, as our motherland. So what happens in these festivals is that we immerse idols during various festivals which has happened. So which has actually impacted the flora and fauna around the river area. So what has NGT done there is, so there's a major festival called as Durga Puja, wherein we celebrate the goddess Durga. And what happens is they want, so when the whole celebrations are complete, so as a mark of respect, we immerse the idol into the river, because the river is considered as a mother. So what has happened is, because of the immense number of idols, that has created a lot of pollution in the river. So what the NGT did, in its landmark judgment, that was that we will create only biodegradable, we'll create idols only made of biodegradable stuff, so that both with respect to the religion which will be there and the sentiments of the people of India, along with respecting the sentiments of the environment as well. So only biodegradable idols will be made. So there was a national law, which a national regulation which was passed, that only biodegradable soil and sand will be used for making of such idols. So no toxicity, and that has greatly improved in such areas, greatly improved the habitat and the fauna around the river areas. Also, another aspect of this is that, so various NGOs that have come into the picture. So what they have done, they have created next to rivers, they've created tanks and artificial tanks and set up like that, wherein the religious aspect and consideration can be taken care of, and not many idols can be immersed in the river, so that the health of the river is maintained. Another major event what has happened is, so that is considering, because India is a tropical country, so we have a lot of floodplains and land of rivers as it's called. So floodplains are very fertile area wherein a lot of agriculture is done. So what happens usually in such areas, at times it happens that many of the organizers want to conduct their events in nearby these floodplain areas, because these are long areas. So what has happened again, so specifically there has been a rule wherein there is a ban on creating any events or whatsoever, any massive events, any events which cater to more than 100 people around these floodplain zone areas. So absolute ban on construction or any parties or whatever next by nearby rivers into the floodplain zones, which thereby impact the floodplains which is around. So another thing, since a lot of sand mining was happening in the various aspects nearby rivers. So what people used to do, that they used to not take permissions, and immediately, because they thought since there are no regulations in place. So what has happened is they have started prohibiting sand mining and more regulating it. So that now what has happened is that people around have started taking care of environment and not taking it for granted, and developed more on the jurisprudence which has been there, and seriously have taken and understood. I mean, at least in the cities, everybody would know what a polluter pays principle is, thanks to the NGT orders which are presently being there. Also, we have, because of the latest efforts by our Honorable Prime Minister regarding digitalization efforts which have been going on. So what has happened is that we have e-courts concept in terms of NGT also. So there is online filing of complaints which are being done. Any layman who do not have access to any specific generalized, specialized lawyers or advocates, what they can do is they can just visit the website and file an online complaint about what they can see in the NGT. Suo moto takes cognizance of it. So there is no. So what has the NGT done? So NGT has made it very easy for the people, so that if they see an environmental violation which is happening, they can immediately write a letter to all the members which are there in the NGT, or the NGT itself immediately address it or file an online complaint, and the NGT will take suo moto cognizance of it. So that acts as a clause which we can say which is there. And apart from that, obviously there's a procedural protocol which happens that can be done. And let me just tell you, all these online complaints are absolutely free of cost. So there is no fee which is charged from the layman if they want, or anybody who wants to raise an environmental issue, especially in a country like that. And such efforts have been really laudable, and that has reduced in corporate cities like metro cities like Delhi and New Delhi and Mumbai and Bangalore. Considerably, the pollution levels have gone down. People have started using public transport, and so on and so forth. Another major issue which was about the mining which is being done in hilly areas. So that was the rat hole mining which was being done. So what had happened was there was inhabitable conditions for the miners who were mining there, and obviously immediate damage to the environment. So bringing a little bit of human rights element also, the NGT has been taken care of, and banned these rat hole mining mines which are there in presently in the northeastern part of India, so that that can be taken care of. So what basically we guys are trying to portray is when a country like India can have a successful model as the National Green Tribunal, catering to so many people, where a lot of people are not legally aware, if I can say, still success has been achieved. And it's not only me who is saying it, it's the statistics who is saying it, and it's the global media who is capturing it. So it's not that I'm just, because I'm trying to put forward the case, I'm just putting in, praises, and just because I belong to India, I'm just saying that this is a successful model. It's the facts and the statistics which are saying so. Also, coming forward to favoring the case of setting up of an ILC, the need of the ILC is to, why is it required? So we have to understand that basically it's a twofold process, and it's a twofold problem which has to be taken care of. One is the environmental problem, and the other is the economic development problem. So what we need to understand is, when we talk about the North-South divide, what we need to understand is there are a lot of developing countries and there are a lot of developed countries. So developing countries need the funds and the resources and the technology, and developed countries have all of that. They need the space and the land to use their technologies. So to form that link, and in between all of this, there is the issue of environment. So when we talk about all of these issues, the major point which comes into thing is, how do we merge these things? How do we bring a balance between the economic development? Because for let's say, I'll just tell you a real life example, which is somebody who is very physically, somebody who is very sick, and they need roads to go to a nearby hospital, but that area lies in front of a wildlife sanctuary. You're not supposed to build roads in the wildlife sanctuary. So how will that person travel for medical aid if that person's space specifically lay there? Because you can't take the right to life from that person, right to live from that person. So economic development, at least in case of India and many of our countries apart, is very important. So how do you bring parity with this, that there has to be a road, there has to be wildlife sanctuary, and there has to be protection of environment? And environment protection is the most important thing which has to be. Now, IELC is
Sharmishtha?
important as, yeah.
Sorry, can we wrap up? But we got to move on to the next speaker.
Sure. So basically what we're trying to put forward a case is that, there has to be an ad hoc arbitral body which can be set up, so which can be converted into a permanent formal international environmental law court, separate from other legal international bodies, as it will exclusively deal with the environmental cases. As simple as that. From the various judicial institution and the specialized courts which are there will be modeled on a distinct arbitral tribunal, but separate, because it will be exclusively environmental court dealing with environmental cases, and which will in a way develop the reliability and confidence amongst the people. And it'll also create what you call environmental legal obligations from the governments, the business people, the NGOs, and facilitate and completely harmonize distinct legislative and judicial systems, and provide access to justice to a broad range of people. So what basically we're trying to say, that build up of an ILC which is within the framework of the Sustainable Development Goals, the COP26, the Paris Agreement, and talking about fragmentation of international law, not dealing specifically with international rules, so that a person on the basis of ICC also and the ICJ, an individual can also, if it's aggrieved, they can immediately go there and talk about a holistic global governance needed for an effective engagement of international interconnected planetary, the transboundary norms, violation of transboundary norms, and develop a mechanism for let's say compensation to the aggrieved parties. So I guess that's talking about quality and longevity of environment and protection against the interests pursued by the multiple stakeholders. Yeah. So I just leave you to the one basic question which I would like to ask you: how does the legal system need to change in order to accommodate the climate protection and the environmental and the economic development which is going to be taking place? So that's the major point on which the whole ILC government is based. Thank you so much.